Let's start. The petitioner M.D. Sarfaraj Alam has approached this court under Article 226 of the Constitution of India, praying for a writ of mandamus directing the respondent authorities to issue a caste certificate in his favor, recognizing him as belonging to the other backward classes within bracket OBC category, as per the notification issued by the Backward Classes Welfare Department, Government of West Bengal. Para. The petitioner claims that he belongs to the Ansari community, which is recognized as an OBC under the state list. He states that his father and elder brother have already been issued valid OBC certificates by the competent authority. However, despite submitting all necessary documents, his application dated 12th June 2024 was rejected without any cogent reason. Para. The petitioner further submits that he requires the caste certificate for applying to government jobs and educational institutions under the reserved category. He contends that the denial of the certificate amounts to arbitrary discrimination and violates his fundamental rights under Article 14, 15 and 16 of the Constitution. Para. The respondents in their affidavit in opposition argue that the petitioner failed to produce adequate proof of his community status. They claim that the local inquiry report did not conclusively establish his social identity and that the application was rejected in accordance with the prescribed guidelines. Para. The learned counsel for the petitioner submits that the rejection order is non-speaking and does not disclose any specific deficiency in the application. He relies on the caste certificates issued to the petitioner's immediate family members and asserts that the authorities acted mechanically and without application of mind. Para. The learned government advocate appearing for the respondents contends that the issuance of caste certificates is a quasi-judicial function and that the authorities are bound to verify each application independently. He submits that the petitioner may reapply with additional documents and the matter will be reconsidered. Para. The core issue for determination is whether the rejection of the petitioner's application for an OBC certificate in the face of existing family certificates and supporting documents is legally sustainable. Para. It is well settled that castes and community status is determined by birth and not by individual conduct in Kumari Madhuri Patil versus Additional Commissioner within bracket 1994 6 SCC 241. The Honorable Supreme Court laid down detailed guidelines for the verification and issuance of caste certificates, emphasizing fairness, transparency, and adherence to due process. Para. In the present case, the petitioner has produced copies of the OBC certificates issued to his father and elder brother, both of whom belong to the same household and community. These certificates were issued by the same subdivisional officer who has now rejected the petitioner's application. Para. The rejection order dated 5th August 2024 merely states that the community status could not be verified without elaborating on the reasons or deficiencies. No opportunity was given to the petitioner to clarify or supplement his application. Para. The court is of the considered view that such a rejection without a proper hearing or responding to order violates the principles of natural justice. The petitioner was entitled to be informed of the grounds or rejection and to be given an opportunity to respond. Para. The doctrine of legitimate expectation is also attracted in this case when similarly placed family members have been granted caste certificates. The petitioner had a legitimate expectation of receiving the same unless there was a clear and justifiable reason to deny it. The respondents have failed to demonstrate any such reason. The local inquiry report as placed on record does not contradict the petitioner's claim but merely states states that further verification is required. This cannot be sole basis for rejection. Para in Director of Tribal Welfare versus L. Giri within bracket 1995 for SCC 32, the Supreme Court held that once a caste certificate is issued to a parent, the same is binding unless proved to be obtained by fraud or misrepresentation. No such allegation has been made in the present case. Stop. Thank